I'm not in agreement with any of it, actually, but I'm going to be responsible and do what I need to do until I can proceed in getting some justification that I need to. But these numbers, I gave her my stuff and it's just not right. I was just trying to get my stuff and I couldn't get it. I wasn't able to get it. So I'm gonna be able to try to get it once I get off the phone. And she sent me the email, and I'm gonna send it to her.
Do you need like a few minutes today to get that pay stub? Because I can give you a few minutes today to get the information you need. But this case has been pending, gosh, since when? We're approaching a year. It's been on file since October 4th. This is
Yeah,
your 1, 2, 3, 4, 5, 6 setting, I believe. Fifth or sixth setting. So I can't reset it, but if you need like some time to get this pay stub today, we can give you a little bit of time to do that.
that wasn't my doing. How it's been drug out.
Okay, and
When
it doesn't matter how it got drug out, but the reality is you've been here, you've done a temporary order, so you're aware of what we're looking at in court. So I can't, unfortunately, I understand you have a lot going on. Hopefully getting this resolved will take one thing off of your plate, but we can't have this just pending forever. I'm under guidelines to move cases forward. Again, this is your fifth or sixth setting, so this needs to go forward today. If you need some time to get a pay stub, I will certainly give you that time though today. If you can get it today. I don't know why you didn't come in with it.
well, because okay, I can go and try to get it. I can do that.
How much time this morning do you need, sir? Let's come up with a time when we're going to start this trial.
Probably about 30 minutes, sir.
Okay. So how about like 11:45 we'll be convening. You need to be here. And you can't leave. You're right. You're just going to be doing this online. You're going to stay here on Zoom.
Yes.
Okay. Please try to get your pay stub and then I guess let someone know if you do receive it and we'll reconvene. But I'm
Okay.
denying the continuance.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. We are back on the record.
So the agreements that the party have reached is that Ms. Harrison will be sole managing conservator, and Mr. Brown possessory conservator. He's also agreed to no visitations with the child at this moment.
Okay.
That the child will stay on governmental assistance with a payout of $75 a month. And if they do have any communications, all communications will be through at close. Okay. And I will call my first witness. Mr. Brown, can you state your name for the record?
Andre Brown.
And are the agreements that I just read before the court what you agree to?
Yes.
Okay. And you were here earlier on May 29, 2025 for temporary orders, correct? Sorry, I couldn't hear you.
Yes.
Okay. And during that time, your child support was set at $632.23 a month, correct?
Yes.
And since the temporary orders, have you paid anything to what was owed during that child support during that order?
No, ma'am.
Okay. Your Honor, I would like to admit as State Exhibit 1 an up-to-date pay record.
Does anyone have any objection to me admitting the up-to-date pay record as State's Exhibit 1?
No objection, Your Honor.
Mr. Brown, do you have any legal objection?
What I just said, or why?
Do you have any
understand.
objections? Do you have any legal objection to me admitting State's Exhibit 1, the pay record? I'm sorry?
No.
Okay, thank you. State's Exhibit 1 is admitted.
So as you can see, as of today, that is owed from the temporary order in child support is $2,532.08 in child support and $300.
Could you repeat that? I can't see that at all. So $2,532.08.
Yes, and I'll make it a little bit bigger. So that is $2,532.08 in child support arrearage, and what is owed in medical support arrearage is $300.38. And I will stop sharing. Okay. And doing the temporary orders, you were originally given a step-up visitation, is that correct?
Yes.
And did you ever execute any of those visits?
No.
Okay. And is that one of the reasons you're no longer you're wanting at this time no visitation with the child?
No, that's not the reason.
So why are you wanting no visitations with the child at this point?
'Cause I have a lot of stuff going, and I
Sorry.
don't know, young
Sir?
lady.
You're
What-
breaking up, so I didn't hear any of that.
Yes.
And I want to hear this because I'm concerned about this.
Okay, so let me try to take this Bluetooth off and put it on speaker or something.
Oh yeah, Bluetooth does not
Second,
work.
please.
Please get off Bluetooth.
Okay.
So I was asking, why is it that you want no visitation with the child?
I don't know this young lady. I know her just about as well as I know you. And there's been some situations over this, and
What young lady, are you talking about your child or are you talking about Miss Harrison?
Miss Harrison.
Okay.
So I'm not gonna put myself,
Objection narrative at this point, Judge.
excuse me.
So
Um,
I'll make it shorter.
Okay.
So when was the last time you saw the child?
Never.
Have you ever reached out to speak to the child?
I don't know. I don't know her. I've said that I don't know her. I don't know her number. I don't know her at all.
Would
We're
you
str-
like to get to know the child?
There's a trust issue. She threatened me,
Objection
and
non-responsive, Your Honor, at this point.
excuse me.
Overruled. You can proceed, Mr. Brown.
She sent a threatening message to my phone on social media, and my daughter seen it. Then they relayed it to me. Then she deleted it. It disappeared. So
Ms. Arredondo, you probably need to ask
Yeah,
questions to
I
make this
am.
not a narrative
So-
at this point. Okay.
When you said she sent a threatening message, when was that?
that was
Objection relevance, Judge. As to,
This is his
Your
reason.
Honor,
Okay.
I would
I'll be
say
honest
this
with you
goes
all.
to-
Let me just stop you for a moment. Agreeing to no visitation is a very big deal. It is certainly not in the family code. So normally agreements I can just roll with and not take testimony on. To do no visitation, I'm going to need testimony and some best interest issues. So if I don't know why he's agreeing to this, I don't know why your client's agreeing to this. So if this is his reason, I don't know that we get to say it's relevant or not relevant. It might not be a reason you and I agree to, or it might not be a reason that makes sense to anyone. But if this is his reason, and that's what he was asked, I think we need to hear it because I think that is relevant to me deciding whether or not I'm going to order visitation. So I guess, Ms. Arredondo, be mindful, and Mr. Brown, be mindful of what the question is. Is this really your reason, or are you just getting information out that you want me to hear? Because I'm listening closely for why you don't want to visit your child. And you may proceed, Ms. Arredondo.
So I was asking, when did this threat happen?
when did the text happen?
Yes.
It was last year, maybe around June or July.
Okay. Did you ever report it?
Yes. I went down to the OG office. I went down there twice.
Did
I
you
went
ever
down there-
report it to the police?
Yes, I did.
And has anything ever come of that reporting?
They told me exactly what to do. They said if it happens again, make sure I keep it, and I need to be able to find that text because she deleted it. So I proceeded to do that.
So has anything other than that one message ever happened?
No, I can't. Not that I can recall as far as the series of that nature. I don't know
And
how
in-
you
Is this the reason why you're not wanting any visits with your child?
The reason is I don't want to put myself in a predicament for trouble. I'm not that type of person. So I can clearly see what this is. I don't know her, so it's an attack thing. That's what it looks like to me. That's what it appears to be. I've spoken with my family.
So do
I
you
spoke
believe that if you had visits with your child, it would be putting yourself in a situation?
absolutely. If somebody threatens you, I mean, all threats are serious. So I can go and meet the child. She can call the police and said I hit her. I don't
So
know,
when you
but
said she made a threat, what are
she
you
said,
interpreting that was in it?
well, I mean, I know it was in it. She said that she had people and she doesn't play. And she had people. She called out one of my kids on the text. She called her by name. I don't know where she get that from, and it was just threatening. Then it disappeared. I guess she realized what she did. She deleted it.
Has she ever made any physical altercations towards you?
What do you mean? No, no.
Okay. And so you're not wanting any visits at all at this point.
I don't want to put myself in a predicament. I don't want to be.
So if you were to have visits through a facility, would you be willing to have visits with the child?
Yes, probably yes.
And if the court was to award visits with the facility, like ABC or supervised visits, do you have anyone that both you and her trust to supervise the visits with the child?
No, I don't know her, so I don't. I got people that I trust. I don't know her, so I don't know a mutual anybody to trust with her.
Um, and are there certain days that you would want these visits to happen if it was through a facility?
Yes,
Okay, what days are those?
that will be Monday on my day off.
Ms. Arredondo, does ABC, do you know what days they have visits? But I don't know that they can
Don't
accommodate.
know.
So I think you have to accommodate them.
Yeah, I'll have to look into that, Your Honor. Yeah.
Okay, so just be aware that, Mr. Brown, when you use these facilities, just so you're both aware, Ms. Harrison and Mr. Brown, there aren't a lot of them. ABC is truly one of the more reliable ones, I have to say. It's established, it's through the courts. But they all kind of, there's a lot of people and there's not many of them. And so it's, you kind of get what you get. And to quote the teachers, you get what you get and you don't throw a fit and you're happy you have it because it's hard to get in them. So anyway, just so you're all aware, that's just the reality. It's just reality.
And Mr. Brown, are you currently employed?
Yes, ma'am.
Okay. And how long have you been at that job?
Been here maybe a little over a year.
And did you provide our office with a up-to-date paycheck stub?
Yes, I did.
And would that paycheck stub be true and accurate of what you are currently making?
Correct.
And is that paycheck stub that you gave us, has it been altered in any way?
No, ma'am.
Your Honor, I would like to admit as State Exhibit 2, Mr. Brown's up-to-date paycheck stub.
And Ms. Charlton, do you have any objection?
No objection, Your Honor.
And Mr. Brown, do you have any objection?
Yes, I kind of do.
What's your
I don't-
legal objection to me? And this is my only question, maybe I should be more clear. Do you have any objection to me admitting your paycheck stub into evidence?
No, ma'am, I don't.
Okay, that was my question. So State's Exhibit 2, I believe?
Yes.
Or State's Exhibit 2 is admitted.
Okay, Your Honor, I'm going to let me know if you can see my screen because I can't tell.
Kind of.
Okay, let me make it
Better
bigger.
than I usually can.
Okay, can y'all see it?
Yeah, and I only see the top half of the pay stub, just so you're aware. It kind of cuts off
Yes,
around.
I'm gonna
Okay.
scroll down.
Hey, Your Honor,
Yes.
I have a question.
I'm not sure I can answer it because this is not really the time for you asking me questions, but what is your question, sir?
Yeah, I didn't know that this is what was about to happen. it being presented to everybody. I have an issue with my personal business. I don't know this person.
Okay.
I understand this is the court. I don't trust none of this situation because I don't know this
Okay.
person.
And I'm hearing you. I'm overruling your objection. You may proceed, Ms. Arredondo, but be mindful. I don't know. Right now, I don't see anything besides numbers, but
Yep.
please be mindful if there is personal information on this pay stub to either redact it or just not show it on the screen.
Yes, Your Honor. And Mr.
Thank you.
Brown, what is the pay period for this paycheck stub?
Uh, that was the last paycheck last week.
Yeah, so does this paycheck stub end as of August 31st, 2025?
I'm not sure. That's the last paycheck that I received.
Okay, can you see my screen?
Yes, ma'am. A little bit here.
And do you see the end date?
I think so.
And do you see that it says August 31st, 2025?
Yes.
Okay. And what do you see that the year to date for this paycheck stub is? And I'll make it bigger if I have to.
You mean the total amount year to date?
Yes.
37,120.22.
Okay. And from this paycheck stub,
Oh, if you can move it up a little so we're not seeing.
yes, sir. Can you see it now?
No, we can see that. It's his address.
Oh, sorry.
Okay, thank you. Well, a little bit more. Okay.
And from this paycheck stub, does that show that your year to date is $4,640.02 per month?
I'm not seeing what you're talking about here.
So, Mr. Brown, when you divide your paycheck stubs by 8, do you see that your monthly gross income would be $4,640.02?
I haven't divided, but I hear what you're saying.
Okay. And this paycheck stubs include some overtime, is that correct?
Yes, ma'am, it does.
And you're not wanting that overtime to be included.
No, ma'am.
And why is that?
For one, it's not not a continuous thing. It's something that happened in the facility, and they made it mandatory for people to come in to help. It was a fire, so they needed to get stuff out, get it cleared up. Other
So
than
when's the
that,
last time you worked overtime?
it's periodically just depends. It may be once a month, maybe once every couple months. It just depends. Um, it's not really like that. I sent in the document from my managers stating what it was.
So there's certain months you work it and certain months you don't.
Yeah, it just depends on the work. If it's heavy, but it's 3 shifts, meaning that it's round the clock. So there's not a lot of room for that. When it gets a little overwhelming, which it very seldom does, then stuff like that will happen. But it's more than one reason for that I don't
So
want
as of this year, what's the last month you remember working overtime?
um I don't know. I think I worked a little bit Sunday.
Okay, so you just worked overtime this Sunday that passed?
Yes.
Okay. And do you have, and I'll stop sharing my screen.
No, please keep sharing. Please.
Oh, sorry. No, you're good. No, you're good.
Excuse me. And honestly, we might have to explore Case Center with you all now that we're doing more of these, because that way I can have the documents and use them as I need to.
I understand, Your Honor. And do you have any other children other than the one before the court under the age of 18?
No, ma'am, I don't.
Okay. And since the child was born up until we did temporary orders, have you ever given Ms. Henderson any type of monetary value or items for the child?
You can stop sharing now.
Okay. Mr. Brown, did you hear my question?
Yes, no.
And have you ever, before temporary orders, reached out to provide any type of help for the child?
No.
Okay. Your Honor, I'll pass this witness.
Ms. Charlton, do you have any questions for Mr. Brown?
Judge, may I be placed on a brief hold? I'm being called in a CPS case.
Oh, yes, yes.
Be 5 minutes.
Okay, thank you for letting
Thank
us know.
you.
Everyone can take a 5-minute break. If anyone needs to go to the bathroom or get some water, feel free. We are back on the record. Ms. Charlton, do you have questions for Mr. Brown?
Yes, thank you. And Mr. Brown, you were aware that the child subject of this suit was born, is that correct?
I didn't hear what you said. And who am I speaking with?
My name is Cecilia Charlton. I'm the attorney for Ms. Harrison.
Okay.
Okay.
Repeat your
You were aware that Araya was born, is that correct?
I was aware that she
Mhm.
was born.
Yes.
Yes, I guess. I mean, you mean, was I there? Or did somebody inform me? I'm not clear what you're talking about.
Okay, you knew that she was born. You answered yes. Okay. And after you were made aware that she was born, have you provided any support prior to the temporary orders being entered for Araya?
No.
Now, you are currently working, is that correct? You testified earlier that you've been working at this establishment for maybe about a year, is that right?
Yes.
Do you do any type of outside work other than this employment that you provided to us today?
No.
Have you ever told Ms. Harrison that you did any other type of employment, like run a business?
No.
Do you have any other source of income other than the employment that you provided for us today?
No. I have a job.
How much did you make roundabout last year?
How much did I make?
Yes, in total.
I'm not sure of that, but I sent them my information already.
Did you make over $100,000 last year?
No.
Did you make over $100,000 in 2023?
No.
Have you ever told anybody that you made over $100,000 per year?
I'm not sure where I said no several times. Man, you're just changing the question up different ways. I've said no 3 times.
Objection argumentative.
Sustained. May proceed.
Sir, do you have any credit cards?
Yeah, I do.
What credit cards do you have?
Do I have to answer this? I mean, I'm trying to understand what this have to do with anything.
Objection to your relevant objection. I'm sorry, overruled. I'm overruling your relevance objection. You may proceed. Please answer, sir.
You want to know, do I have credit cards? I said yes. What else did you say?
What credit cards do you have?
I have a few credit cards.
You have an Amex credit card?
Say that again?
You have an Amex credit card?
Yes, I do.
What income did you provide on your application for Amex?
What income did I provide on my credit card for Amex? The income that I provided on my credit card was my household income, meaning I have a family. So that's what it was. If that's what you're asking, you could have directly asked that, and I would have just told you.
Objection,
So
non-responsive.
So, sir, please just answer the question asked and don't give commentary.
I don't know if you're asking me the amount I put on there. I'm not sure.
You indicated that you made over $200,000. Is that correct?
I don't think so, but I'm not sure.
Judge, may I have permission to share my screen?
Good luck with that.
You may, who is host? They have to make you co-host. Ms. Crawford, can you make her a co-host, please?
Judge, at this time, I ask the court to take judicial notice of the notice of filing of business record affidavit from American Express that was filed with the court on March of 2025, March 11, 2025.
I take judicial notice of that notice signed by the Assistant Custodian of Records. Contained 193 pages from American Express. So I take judicial notice of that filing.
At this time, I offer Exhibit 1 into evidence.
What is Exhibit 1?
The notice of filing a business record affidavit with the accompanying records.
The records weren't filed, so I don't, you have it compiled as an exhibit.
Yes, I do.
Okay, who is talking? I can't see the chair.
I'm sorry. I'm sorry, I'm out in the hallway.
Yeah, okay, sure. Just want to make sure it's. Does anyone have any objection to me admitting CP's Exhibit 1?
No objection, Your Honor.
I have no idea how we're going to keep those records as a practical matter, but sir, do you have any objection to State's Exhibit 1 being admitted? I'm sorry, I couldn't hear you, sir.
What is the business affidavit? What is this?
It is it's 193 pages of Amex records that she filed with the court. And I believe did you CC him? Did he get notice?
Yes, at that time, he was represented by counsel, Judge.
Okay, so your counsel was sent a copy.
No, no, I didn't have it.
Okay, do you have any legal objection to me admitting these records?
I guess not. I'm not really understanding, but no.
Okay, CP's Exhibit 1 is admitted.
Now, Mr. Brown, you indicated that you do have this Amex, is that correct?
Yes.
Oh, okay, whoa. Please put that down. We're on YouTube.
Oh, I
it
didn't
was a
realize
Social
it. I'm
Security
sorry.
number. So please don't do that. I'm actually going to, if someone can pause the YouTube, I'm going to delete the YouTube and come back into this hearing.
Okay.
So please, everyone, be mindful of YouTube, and the person who's hosted, you can stop the YouTube, please. Okay, we are back on the record in cause number 24-10-15463. Mr. Brown, Ms. Harrison, Ms. Harrison's attorney, Ms. Charlton, and Ms. Arredondo are all present as well. I guess, Mr. Brown, did you have any more questions for Ms. Harrison?
No, not at the time.
Okay, thank you. Ms. Arredondo, do you have any redirect you'd like to do? Oh, you're on mute.
Okay, can you hear me now?
We can hear you now.
Okay. Hi, Ms. Harrison, you mentioned that you were made aware of Mr. Brown's some criminal history. How were you made aware of that?
I did a research of him myself because of just some stuff that was happening, and that's how I came up with the information.
And do you know if all of these have concluded or not?
Say that one more time, I'm
Do
sorry.
you know if any of these cases that you searched, have they concluded?
Yeah, I believe so, yes.
Okay. And as far as you're aware, do you know if he was ever convicted of any of these crimes?
No, I'm not sure.
Okay. And then you gave testimony earlier that the two of y'all, I think you used the quote, had business together. What did you mean by that?
We were going to go into real estate together. He wanted to do properties. I'm connected to a lot of real estate agents. He mentioned that in Florida, because he's from Florida, that he would purchase homes, flip them, sell them, rent them
And
out.
did that business ever come about?
No.
No further questions for this witness, Your Honor.
Okay. Ms. Charlton, do you have anything further for Ms. Harrison?
No, Your Honor. No.
Thank you. And Mr. Brown, just one more time.
For Ms. Harrison, yes,
Okay,
I have a question. So Ms. Harrison, you have a child or someone you don't know. What were you expecting out of this?
Objection, Your Honor, to relevance.
sustained. Do you have any other questions, sir?
No, ma'am, I don't.
Okay. Ms. Arredondo, do you have any other witnesses?
No other witnesses, Your Honor.
Ms. Charlton, do you have any witnesses?
No other witnesses, Your Honor.
And Mr. Brown, since you're not here with representation and the state does not represent you, this is your chance if there's anything you'd like to say that's relevant to this case. Ms. Charlton, feel free to make any legal objections you feel are appropriate. Sir, is there anything you'd like to say?
Yes, feel that my rights are being violated to due process. I've spoken about a few things here that just seem to be overlooked and passed on.
Sir, this is your chance to speak if you feel things need to be fleshed out more. This is how court works.
I spoke about what took place here.
Sir, you're breaking
I
up, so
gave
at
you,
this point, sir, I can't hear what you're saying because you're breaking up.
I said I spoke about what was taking place step by step, what took place with me, what happened, and how I view it. And I don't see where it would be relevant or to do any good to put myself in a position where I don't trust the other person. And it seems like you're just kind of walking into some type of trap. And that's what it's been presenting to me. So I had this discussion, like I said, with my family, with the police department, and a couple of officers in my neighborhood. And this is what they advised me to do. So I relayed that over to you guys. I went down to your office.
Sir, let me just say, you're speaking to the judge now. I don't even have an office. You did not come down to my office and talk to me, and you would be
I'm
inappropriate
sorry.
for you to do that.
I went
So
down.
just remember, this is not you against the AG's office. This
Yes.
is really not even you against Ms. Harrison. This is about your child. So please continue.
Yeah. It's not in reference to the child. The child is innocent in all of this. The thing is, I don't feel comfortable. You have to feel comfortable, and I see that. I mean, I'm just not really being heard here. So that's why I'm feel like my rights are being overlooked and violated. The attorney spoke about a few things. He was very direct and very kind of aggressive a little bit. I felt very uncomfortable with that. Information about my personal life, very uncomfortable with that also. I've been here and been to the hearings every time. I didn't put it this far out. I was here from the drivel. Like I said, I hired an attorney because of the threats. It wasn't about the support. All I got to do is just turn in my information. Even if I didn't agree with it, I turned in my information. So I was doing the right thing. That's all.
Is there anything you'd like to say about child support or back child support or any of the issues I'm going to be ruling on?
Did he freeze?
I think so. So I'm not sure he heard me.
Can you hear me?
We can hear you, sir. Did you hear me, sir?
Uh, 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 what did you say?
Do you have anything you'd like to say about child support or back child support or any of the issues I'm ruling on today?
Hello?
Are you back on Bluetooth, sir?
No, I don't know what happened. I think it froze.
Okay. Do you have anything you'd like to say about child support or back child support or any of the issues I'm ruling on today?
Yes, ma'am. concerning the numbers on the support, the overtime, it's just not something that goes on, and I'm not really able to work it like that anyway. So that's another issue. Um, I'm of age. I'm over 50, and I'm just not physically able to be doing all of that work. So I'm not really for that or able to do it like that. So it was mandatory at that time, and that's what it was. With that, those numbers are exceeding what I can do. So I have to make arrangements, and it looks like I have to just leave some stuff alone. Oh, hello?
We're here, sir. We're listening to you.
But that's pretty much it. I just don't feel comfortable. And the numbers are off, and that overtime inflates it, and it can't fit in the butt. It can't fit if I'm able to do something that I can. It doesn't have to be that I can work with it. Just be able to survive and live. Then I will be fine. But if my life is going to be destroyed and my family is suffering through this, and they don't have to because they don't have anything to do with this, that becomes difficult. So, but that's it.
Ms. Arredondo, do you have any cross-examination of Mr. Brown?
No, Your Honor.
Ms. Charlton, do you have any cross-examination of Mr. Brown?
No, Your Honor.
Would you all like to make brief closings to summarize what you're asking for? You may
Yes, Your
start.
Honor. Your Honor, we're asking that Ms. Harrison be appointed sole managing conservator as the parties originally agreed. We are asking that you make a determination as far as the visitation is concerned. We are asking that the governmental assistance continues at $75 a month. We are asking that the child support be based off of the pay stubs presented and how Mr. Brown presented that he did just do overtime on Sunday, that the child support be set at $765 a month. We are asking that app close be continued into the final order. We are asking that a child support judgment from the prior order be entered as of September 11th in the amount of $2,532.08, and a medical support judgment be entered in the amount of $300.38, with the court presenting a reasonable payout amount for those two amounts. And then we're also asking for retro child support in the amount of $9,061.22, Your Honor. And that's it, Your Honor.
Thank you. Ms. Charlton, would you like to make a brief closing summarizing what you're requesting for Ms. Harrison?
Yes, Your Honor. May I proceed?
You may proceed. Thank you.
Judge, we're asking at the conclusion of today that the court accepts the parties' agreements that Ms. Harrison will be named sole managing conservator of the child subject of the suit, that adjudication of Mr. Brown's paternity follow from the temporary order to the final order, that he be named a possessory conservator. And for the visitation, Judge, what we are specifically asking is that the court honor the parties' agreements that there will be no visits for the child. Alternatively, between the child and Mr. Brown. Alternatively, the court finds that that's not in the child's best interest. We're asking that the court order supervised visits with the specified entity, Judge, and that Mr. Brown be responsible for all fees associated with the supervised entity. We are asking for a step up as well if those visits are not going to be definite upon modification. As it relates to the child support, we are asking that his current obligation be $765 a month as requested by the Office of Attorney General. We are asking that the court order that a child support judgment be issued for the amount of child support and medical support not paid from the temporary orders to current. And Judge, we are asking, and we believe the testimony provided by Ms. Harrison today, along with Mr. Brown, indicates that a retroactive child support judgment in the amount of $9,000, $61.22 is in the best interest of the child. And we are asking the court to order that along with the required payout provision for Mr. Brown beginning on the 1st of October.
And Mr. Brown, would you like to make a summary of what you are requesting?
I don't agree with any of it.
Okay. And what are you actually asking that I order then?
It seems like we're talking about money, and you're gonna do. You're being really nice, and I like how you come across. So I really don't have anything else to say. I've stated that. I don't have any charges, whatever she's talking about. I really wasn't gonna address that, but I'm gonna say it. It's complete, whatever you want to call it, don't exist. Um, that's pretty much it. I don't have anything else to say about it. I don't feel good. I feel depressed. I feel strained. I have people in my family that are on their deathbed. Um, my kids are concerned about me because I've left my home. So my family is broken up. This is what I want to say. And this is my doing because I'm their protector and I'm not going to drag them through something that I didn't cause. So this is the situation. It looks like one thing, but this is clear. A high form of manipulation. It's just what it is. I've been working pretty much a long time, doing the right thing, taking care of my family. I have no small children, no small kids at all. So
You're back on the record again in clause number 24-10-15463. And I am rendering now, based on the evidence and testimony presented to me, I am ordering that, and I'm approving part of the agreements, I am ordering that Ms. Harrison is the managing conservator and that Mr. Brown will be the possessory conservator of the child. I am establishing the parent-child relationship between Mr. Brown and the child as well, sorry about that, as was done in the temporary order, and the child's last name will remain Brown, as it currently is. I am ordering that Mr. Brown have visits through the ABC program. I'm ordering that the costs be split with Mr. Brown paying 75% and Mom, Ms. Harrison, paying 25% of the fees associated with it. I'm ordering that the parties contact the ABC people within 30 days of this order. So I know you're not interested in visitation. I do hope you change your mind. Obviously, things were not perfect when this child was conceived, and they have not been perfect since then. But at the end of the day, this really is about Araya. It's really about Araya, and you really might regret one day not knowing her, and she really might regret not knowing her dad. So I am ordering the visits. Do be aware, though, if you all don't use these, I think at some point ABC might kick you off the books, because as I said, there's not a lot of them, and there's a lot of people needing the services. So I'm ordering it in here, but if you change your mind 5 years from now, I don't know what will happen. So that is visitation. I am finding that nobody has access to private health insurance at a reasonable cost. And I'm ordering that Ms. Harrison continue with a government or medical assistance program. And I am ordering that Mr. Brown pay Ms. Harrison cash medical support of $75 per month beginning October 1st of 2025 and monthly thereafter. Based on the testimony and evidence presented, I'm ordering that Mr. Brown pay to Ms. Harrison child support of $765 per month beginning October 1st, 2025. I'm ordering a back child support judgment against Mr. Brown. I'm ordering the back child support in the amount of $7,467.92. I'm confirming the arrears judgment of $2,532.08, So I'm taking a cumulative judgment of $11,000 as of today, September 11th, 2025. And I'm ordering that Mr. Brown pay that judgment back at a rate of $75 per month, beginning October 1st of 2025. Don't usually talk about this. It is in the orders, and it is in the family code. Children issues are subject to modification. So hopefully, I'm really hoping over time, you'll all modify this visitation. And sir, if things don't go well at the job, or things change, or you age, or whatever happens, you can file to modify child support as well. But right now, I'm basing this ruling on where things are today as I've heard them today. So the state is going to draft the order.
Real quick, Your Honor, is the app close still coming forward?
Oh, yes, I'm sorry. Thank you for reminding me. Yes, and I'm continuing the app close. Is there anything else
And then what's the payout amount for the medical support?
Oh, yes, I'm also confirming a medical support judgment. What was that number? Of $300.38. So I'm going to order that paid out at a rate of $5 per month. And that judgment is as of today, and the payout of $5 will start on October 1st, 2025, and monthly thereafter. Okay. And do y'all need an entry date, or are you gonna draft it today?
I can draft it today, Your Honor, and send it to all parties to review and sign. So
Okay.
if they can just, Ms. Crawford, if you can just quickly move them into a breakout room, I'll make those changes to the temporary order and send it to all parties to review.
Okay. Absolutely.
Thank you.
Your Honor,
Thank
could
you,
you make me
Gemma.
host when you get a chance, please?
Oh, yes, I'm so sorry.
And I have to switch on a different device. This one is actually going, so I think I've logged into the waiting room. I just need to be let in.
Okay, thank you. I'm going to start moving you into waiting rooms.